can provide legally segregate schools and other government facilities so long as those facilities are equal. Well, the truth, as history has shown, for the most part, those facilities were never equal. Quite frankly, except in Topeka, Kansas, to be honest with you. We did have equal facilities. But anyway, so, however, my father, along with the other attorneys, Charles Bledsoe and John Scott, and also along with the counsel from the National NAACP Legal Defense Fund, Jack Greenberg and Robert Carter, made the decision, notwithstanding that Topeka had equal and quality schools with those of whites, that the institution of segregation needed to be challenged. And they needed a vehicle by which the institution of segregation could be challenged. And that segregation itself, regardless of whether the facilities were equal or not, could only be challenged if the facilities for blacks and white children were equal. And that's what they did. And the biggest challenge of my father and the other attorneys was to try to find parents and children who could serve as plaintiffs to bring the lawsuit. And that was a hard sell. It was hard to convince people to bring a lawsuit to abolish a school system that provided your children with basically a quality education. Let me know. Okay. Well, anyway, the bottom line was they brought the case, but nonetheless, there were 28 parents, or excuse me, roughly 28 parents and their children who agreed to serve as plaintiffs in the case, and the Brown case was brought. And I think, and I'll just leave this with my last comment on that regard would be that the reason why those parents chose to serve as plaintiffs in the Brown v. Board of Education case, even though their children were getting a good quality education, they knew for the future that their children's rights and opportunities would be limited in a segregated society. And that they were not only seeking to end segregation within the school system, but to seek to end segregation throughout American society. Long story short, the case was filed, and the Supreme Court ruled in May 17, 1954, that segregation in public schools is inherently unequal, even notwithstanding, or even though the facilities, the tangible educational facilities, are equal. And with that, I'll conclude and leave it open for questions later.
Thank you, Mr. Scott. At this time, I'm going to check with Johnson C. Smith and Internet 2 office in Washington. Do we have our other panelists with us yet?
Jerry Stokes is reporting in.
Thank you, Mr. Stokes.
Good morning.
Good to see you. Good morning.
Good morning. Good morning, Dr. Henderson.
Is Brummett Delane with us at Johnson C. Smith?
Yes, I am.
Okay, great. All right. Cheryl, do you want to go next? And then, okay. Nice to see you, Brummett. Okay, so we're going to move on next to Cheryl Brown Henderson, who was the daughter of Oliver L. Brown. And she'll talk about her family history and the Brown case. And then after that, we'll go on to B.B. Delane, okay? Thank you.
Good morning, everyone. I think this is an amazing opportunity that you all have out in North Dakota and Nebraska and other parts of Kansas and Missouri to hear firsthand from people whose families were involved in changing things. As you heard Attorney Scott say, you know, it made such a difference in all of our lives to have Brown v. Board decided the way it was decided by the Supreme Court. I want to make a few points and kind of back what he said. First of all, the point I'd like to make is that Brown versus the Board of Education, just so you can understand it as a practical matter, was about the country, their reluctance not to obey the Constitution. Basically, the United States government, local governments, state governments were not obeying the Constitution. The Constitution of the United States back after the Civil War gave African Americans the rights to become citizens, and that was the 14th Amendment to the Constitution. It also offered equal protection under the law, which meant we had to be treated fairly. So basically, the country was not obeying those parts of the Constitution. So the NAACP that you heard Charles mention, the National Association for the Advancement of Colored People, which is an organization that was established by both whites and African Americans because we wanted a better life for people of color and people that were being treated unfairly in this country. So that organization made its principal focus, the main thing it wanted to do was to get the country, get the government to obey the Constitution, in particular the 14th and 15th Amendments to the Constitution. The 15th Amendment gave African American men the right to vote, because ladies, all of you young women out there, we didn't get the right to vote until 1920, so that was to come much later. The other point I want to make is that Brown was all about what parents wanted for their children. So the reason people were ultimately willing to volunteer when people came to their door or when they were being organized to become plaintiffs in this case, it was all about what they wanted for their children. Charles talked about that. Your parents want the same thing for you that our parents wanted for us, and that's a good education, an ability to make a living, to have a good life, to be able to choose what you want to do with your life. It was all about what parents want for their children. Charles's father, ironically, was the person that asked my father to become involved in the Topeka case. The Topeka case was a combination of 13 families, a total of 20 children represented. So a lot of your textbooks will have you believe that the Topeka case was all about Oliver Brown wanting to make a better way for his daughter, Linda Brown, to get to school. And we're here to tell you today that those textbooks are absolutely wrong. I always talk about the Internet being our worst enemy, because 99.9% of what's on the Internet about Brown v. Board is fictionalized and just flat out false. So when you're doing your research, I would encourage you to come to the National Park website or the Brown Foundation website, Howard University website. There are a few, but the majority are going to lead you down a path of not really understanding what happened. The third point I want to make is Brown v. Board, once it was decided, opened the doors for everyone, not simply African Americans, because the Supreme Court decided that the country really did need to understand the Constitution better. That's what the Supreme Court does. So basically it said that that Equal Protection Clause of the 14th Amendment applied to everybody, and local governments and state governments had no right to restrict people from their freedoms afforded through the founding documents of this country. So for the young ladies that are out there listening this morning, Brown v. Board resulted ultimately in Title IX, which allows you an opportunity to play sports. I can't see you right now, so I won't ask for a show of hands about how many of you are playing soccer or basketball or baseball in your schools and in your communities. That wasn't the case prior to Brown and then prior to the Civil Rights Act. Girls were not afforded the same opportunities as young men to play sports at the collegiate level or other levels. The other outcome of Brown, you think about going to the movies, you think about going to the mall, you think about living any place in your community. You know, that simple act of standing up, or parents joining forces, being willing to become plaintiffs, with attorneys going through the legal maneuvering to bring that case all the way to the Supreme Court, resulted in your ability, whether you are white, Hispanic, Asian, African American, women, men, disabled, those rights for you to go to the movies freely, for you to go to the malls and shop freely, for you to live wherever you wanted to live in your community. Brown v. Board did that for all of us. So I think it's important to note that even though African Americans were leading the charge, the outcome really benefited every single citizen in this nation. Finally, when you think about what parents want for their children, you think about what your parents want for you, and I think about what our parents wanted for us, and in particular, Brummett Delane and John Stokes that you'll hear from in a minute. How could you really get an equal education if in your classrooms you were using old textbooks with missing pages? How could you get an equal education if what you wanted to do was to be a doctor and there was no science laboratory in your school? And how could you get an equal education if it took you, let's say, an hour to get to school,